My name is Jorge Viñuales. I'm a professor of law and environmental policy at the University of Cambridge, as well as the director of the Center for Environment, Energy and Natural Resource Governance at Cambridge. The purpose of my lecture today is the customary principles of environmental protection as they have developed over the last 20 years and their implications for a number of areas of international law. More specifically, what I would like to address are three main points. The first are, what are these principles and what are their interactions? The second is basically what are the clarifications that are needed if these principles that have been distilled over the years by the case law of international courts and tribunals were to be generalized to a number of other situations. And the third point is, what are some principles that right now, although they are not recognized unanimously as customary principles of international environmental law, what principles may in fact become recognized in the near or medium term as customary principles of international environmental law. After doing these three steps, my conclusion will be what are the implications for different areas of international law, and I will be looking at three main areas in particular. So let me go directly to the first point. The first point really can use as a starting point paragraph 104 of a decision of the International Court of Justice of December 2015 in the case between Costa Rica and Nicaragua. In that decision, the court, in that paragraph, the court summarizes in just one paragraph, and that's quite exceptional, the four main principles of international environmental law at this time. The main principle, the one from which other principles flow, is the broad concept of due diligence. Due diligence is a concept that has a broader scope than just environmental protection, but it does apply also in environmental matters. And the expression in the field of environmental law is the cornerstone of international environmental law, the prevention principle that has been formulated in Principle 21 of the Stockholm Declaration of 1972 and Principle 2 of the Rio Declaration of 1992. The principle of prevention is in turn manifested or spelled out in a procedural way through two other principles. First, the principle of cooperation, which is, again, a very general obligation that has a broader scope than just environmental protection, but that has a very specific meaning in environmental matters, namely notification and consultation where there is a risk of transboundary environmental harm or harm to the global commons. And the second procedural manifestation is the principle of environmental impact assessment. So these four principles, due diligence, prevention, cooperation as notification and consultation, and environmental impact assessment, have been recognized in the case law in the last several years, but particularly since 1996, with this very important advisory opinion rendered by the International Court of Justice in the case concerning the legality of the threat or the use of nuclear weapons. In that advisory opinion, for the first time, the court recognized in paragraph 29 that Principle 21 of the Stockholm Declaration and 2 of the Rio Declaration were manifestations of the general corpus of international law, and that should be understood as general international law, or in other words, customary international law. And since then, tribunals at the international level have consistently recognized that principle, as well as more and more its procedural manifestations. The next step came really in 2010 in the case between Argentina and Uruguay of the pulp mills of the River Uruguay. And in that case, the court not only recognized the connections between these different principles, but it also, for the first time, recognized that the principle of the requirement of a prior environmental impact assessment was also an expression of general international law. Since then, the case law has been quite consistent, and today we can very safely affirm that these four principles are principles of customary international law in this area. Now, of course, the interactions between these principles is not necessarily an easy one, because they may intervene in a sequential order, as suggested by the case that I just mentioned between Costa Rica and Uruguay of 2015, or more generally, they may intervene at the same time. Let me just state first a sequential order, and then I will add some clarifications to that order. So, the court in the Costa Rica-Nicaragua case followed the ideas of the International Law Commission codification efforts regarding articles on prevention of 2001, and stated that the process through which these different principles apply are: first, due diligence would require from a state some form of preliminary assessment of the implications of an activity, and if that preliminary assessment, that may take a variety of forms, were to yield a result that suggests that there may be a risk of transboundary environmental harm, then that risk must be ascertained again or confirmed by an environmental impact assessment. If the environmental impact assessment confirms that there is indeed a risk of significant transboundary harm, then the state has the obligation to notify and consult with the potentially affected state. So that sequence is the sequence that the court followed in the Costa Rica-Nicaragua case, but it's a sequence that is not necessarily capable of being generalized for many other situations. And what I would like to do as a second step, moving to my second step in this presentation, is really to discuss some other ways in which these principles, in fact, may interact in practice. So in this second step, I would like to make three basic points. The first point is that this customary matrix of international environmental law applies irrespective of whether there is a dispute over a territory or over a maritime area. So there are a number of decisions that have recognized that these principles apply irrespective of the existence of a dispute, and that suggests that even if environmental protection, or the legal expression of environmental protection, has not reached jus cogens status today, not yet at least, it already enjoys some level of hierarchy, some objectivity that makes those principles applicable even in situations where the parties do not agree on the status of an area or a territory. That's a very important point, and has been asserted by the at least three tribunals, as I was saying. One is the ITLOS, the International Tribunal for the Law of the Sea, in an advisory opinion of 2016 over a question of illegal, unregulated, and unreported fishing. And then again ITLOS, but this time in a provisional measure case between Ivory Coast and Ghana. And thirdly, it has been noted by a tribunal organized under Annex 7 of the United Nations Convention on the Law of the Sea in a case between the Philippines and China. So in those three cases, there was recognition of the fact that this customary matrix applies despite the fact that there may be a dispute over the area. Second point. I mentioned earlier that even before the environmental impact assessment confirms the existence of a transboundary environmental risk, there is a process of initial or preliminary ascertainment of whether there may be a risk. Now, that process that is in the hands of a state is not a process that is unregulated. That process is not at the entire discretion of the state where the activity is being conducted. In fact, that process is being fully governed by due diligence and prevention. So the due diligence and prevention principles are already demanding from states that at that point they not only have a sufficient legal framework to assess this risk before conducting an environmental impact assessment, but that framework is actually applied. So there is a proactive duty, a proactive due diligence duty of making sure that the risk is sufficiently and diligently ascertained. So what are the implications or the practical implications of that clarification? Well, in fact, if a state were to decide unilaterally that there is no risk, despite the fact that it has conducted a preliminary ascertainment of environmental risk, that would not be enough, and that decision, that unilateral decision, that discretionary decision of a state could be actually reviewed by an international tribunal, and the International Court of Justice indeed reviewed that type of decision in the case between Costa Rica and Nicaragua. So the process is being governed by international law since the very beginning. It's not something that only starts to be governed at the level of the environmental impact assessment requirement. So that clarification is, I think, very important because it dispels some of the concerns of the environmental community after the decision of 2015. Due diligence remains, and it requires a wide variety of steps to be taken by states, although those steps may intervene before reaching the level of the obligation to conduct an environmental impact assessment in customary international law. The third clarification that I would like to make is that even after the environmental impact assessment has been conducted and it has confirmed that there exists a risk of significant transboundary environmental harm, even when the environmental impact assessment obligation and the cooperation obligation take over, even at that level, prevention and due diligence continue to apply. So prevention and due diligence do not apply only at the beginning and then no longer. Prevention and due diligence accompany the entire process. And in fact, the requirement to conduct an environmental impact assessment in the same way as the cooperation obligation are manifestations of prevention, are manifestations of due diligence. Now, what would be the implications, the practical implications? Well, one could think of a state conducting under its regulatory framework an environmental impact assessment that is deficient. In that case, the question is whether that deficient environmental impact assessment is enough to meet the obligation to conduct an environmental impact assessment. There are two possible answers. One is, well, it satisfies the obligation to conduct an environmental impact assessment, but it may not necessarily satisfy the due diligence obligation. And the other potential answer to the question is, well, in fact, because both the environmental impact assessment requirement and the due diligence obligations have to be read as one, then that deficient environmental impact assessment is not satisfying either obligation. So international environmental law, and particularly the obligation of due diligence, continue to apply even once the environmental impact assessment obligation has come into play. The same applies to the cooperation obligation. One may read in most of the cases that have addressed this question that cooperation means, in a transboundary context, mostly notification and consultation. but cooperation may mean much more than that. The fact that two manifestations of the obligation to cooperate in good faith are the obligation to notify and the obligation to consult, as stated in Principle 19 of the Rio Declaration. The fact that there are these two specific manifestations of the obligation to cooperate does not mean that there are not other manifestations of the obligation to cooperate. So that is very important, because there may be cases where the obligation to cooperate requires a state to enter into consultation not just with another potentially affected states, but also with international organizations that are particularly apposite for a given environmental problem. That has been also suggested in the case law of the International Court of Justice. So these three clarifications of the initial sequence are important for the proper understanding of the customary matrix of international environmental law. But at the same time, there are other potential manifestations of the obligation of due diligence, and particularly of due diligence in the context of environmental protection, that have not yet been recognized to this day as having a customary grounding, but that I would say I believe that are ripe for recognition in the near future. And those other potential principles of customary international environmental law are mainly two. The first is a precautionary principle or approach. Today, international courts and tribunals are divided over whether there is a precautionary principle or a precautionary approach in customary international law. Some courts, particularly the European Court of Human Rights, have considered that there is indeed a precautionary principle with customary grounding, and some other tribunals have preferred not to state openly whether such is the case. By way of illustration, the International Tribunal for the Law of the Sea, and more specifically the Seabed Chamber, in an advisory opinion of 2011 over the responsibilities of states sponsoring activities in the area, mentioned that the precautionary approach was indeed a manifestation of due diligence, and that it had customary grounding in statu nascendi, or was a principle that was emerging slowly as a customary norm. Similarly, the International Court of Justice, in the pulp mills case that I mentioned earlier between Argentina and Uruguay, decided in 2010, mentioned that the precautionary approach may be relevant to interpret some other provisions of the applicable treaty in that case. So there is an emerging recognition, and the main debates that existed since 1992, during the 1990s and early 2000s, with respect to whether this principle or approach had sufficient content to be characterized as a norm of customary international law, I guess could be assuaged, or at least not put to rest, but at least addressed sufficiently by reference to Principle 15 of the Rio Declaration, which provide a canonical formulation for the precautionary principle or approach. So I believe that this norm, or this principle or approach, will in the next years become widely acknowledged as part of customary international law, and particularly as a manifestation, an additional manifestation of due diligence on environmental matters. The second principle that I believe will be recognized in the same context is the principle of public participation in environmental matters. Now, public participation has a very solid grounding in human rights law. Regional courts of human rights, whether in the Americas, in Africa, in Europe, have recognized or have interpreted general human rights in an environmental light, and rights such as the right to property in the American Convention on Human Rights, or the right to private and family life in the European Convention of Human Rights, or the right to a generally satisfactory environment, or to natural resources in the African Charter of Human and People's Rights, have been read as having some form of procedural components that require public participation from affected communities. Now, those are rights, and those rights, for some, it's difficult to read those rights as a principle. Yet, as I was mentioning for the precautionary approach or precautionary principle, the Rio Declaration of 1992, and particularly Principle 10 of the Rio Declaration, has stated that public participation is a principle, and it has been referred to by some of these human rights courts, regional courts, as evidence of the existence of a norm to interpret the general human rights. So I think that the formulation provided in Principle 10 is a very useful starting point for the recognition of a customary principle of public participation in environmental matters. Last but not least, I would like to mention something which is difficult to call a principle, but is a technique for interpreting treaties and norms in an environmental light that was initially recognized in the opinion of Judge Vera Mantri in the Gapchikovo-Nagimaros case decided by the International Court of Justice in 1997. Judge Vera Mantri in that case spoke about a principle of contemporaneity in the application of environmental norms. Stated in other terms, that would mean that treaties, whether they refer to environmental matters or not, treaties have to be interpreted in the light of the existing environmental norms at the time of the application of the treaty, not at the time of conclusion of the treaty. And there is authority for this proposition. In fact, there is some significant authority if one looks at a wide body of case law, but the main or more clear recognition of that principle was made in 2005 by an interstate arbitral tribunal deciding a case concerning the Iron Rhine between Belgium and the Netherlands. The main point is that a treaty, even a very old treaty, may have to be interpreted in an environmental light. I call that perhaps the environmental fine print. At any time, a treaty may be read in an environmental light, despite the fact that the treaty itself does not call for that, or despite the fact that environmental protection has not reached the status of jus cogens. So again, going back to what I mentioned earlier, this is yet another recognition that environmental protection principles, despite the fact that they have not yet reached jus cogens level, they display nevertheless some specific and particular effects that make them more objective. So far I have been developing 3 points. The 3 points are: first, what is the customary matrix of environmental protection? And I referred to paragraph 104 of the Costa Rica-Nicaragua case. Then I discussed the sequence of those principles. Then I added some clarifications, 3 main clarifications to that sequence, and I said that these principles apply despite the fact that the territory or the area may be disputed. I also mentioned that these principles start to apply even before there is a confirmation by an environmental impact assessment that there is significant transboundary environmental, that there may be significant transboundary environmental harm. and that even once there have been that confirmation, these principles continue to apply as a whole. So the next step that I made were the sort of identification, was the identification of some potential principles to be recognized in the future, and I mentioned the precautionary approach and the public participation approach, and lastly this principle of environmental interpretation, for lack of a better term. What I would like to do now in concluding is flagging a number of areas for which these developments in the customary law of environmental protection may be particularly important. And I would like to mention three areas. The first area is, of course, the law of the sea. In the law of the sea, the United Nations Convention on the Law of the Sea has a very advanced and very sophisticated part 12, that governs environmental protection of the marine environment. Now, that part has been interpreted in a number of recent decisions as articulating, manifesting a customary matrix of environmental protection. So Article 192 and 194 of the Convention have been interpreted as reflecting in a way or manifesting more specifically the principle of prevention and due diligence. There have been a number of decisions where these principles have been applied, including the recent decision on the South China Sea, and I believe that in this area environmental protection will not only continue to be relevant, but will become more and more relevant given the type of uses that states are envisaging for the oceans. The second area where there has been a major impact of environmental considerations in practice is investment arbitration. If one compares the number of cases with environmental components that had been filed between the 1970s and 2012, and from 2012 onwards, in fact, from 2012 onwards, the number of cases with environmental component, the number of investment cases with environmental components has really skyrocketed. We have more than the number since 2012 that at any time before. And almost every month, and I would be even tempted to say every week, one sees a new case filed which is related in some way to environmental protection, and the main area for this is, of course, energy transition policies and extractive industries. By flagging this issue, I also want to flag the fact that public participation in environmental matters is going to become more and more important. Of course, cases concerning extractive industries necessarily imply a very important public participation dimension, and unless this is fully recognized, these cases will not give sufficient importance and sufficient recognition to public policy, I would say, or public interest. And there is right now, of course, a trend towards the adjustment of the system of investment protection and particularly investment arbitration. The third area where I believe environmental protection is going to take more and more, become more and more important is human rights. Of course, human rights and environmental protection have entertained a virtuous relation, a synergistic relation since at least the early 1990s in a variety of regional human rights settings. But today, as I speak, there is a request for an advisory opinion of the Inter-American Court of Human Rights on the implications of environmental protection for the extraterritorial scope of human rights provisions. So we are expanding expanding the relationship between human rights and the environment, and this will continue in the future. So I believe that this customary matrix of environmental protection has become and will become more and more present in international dispute settlement in the future, and I hope that these very brief observations on the customary norms of environmental protection will be of use for practitioners and academics in their work, and of course to protect the environment. Thank you very much.